If people join, they can join.
Okay, thank you all for joining this part. I'm Sonja Snacken. I'm Emeritus Professor in Brussels at university. I've been working for many years on research on prisons and community sanctions, and for the last 20 years trying to integrate empirical research in those forms of punishment and human rights concerns. I have been an expert to the CPT. I've been the chair of the Penological Council, drafting European prison rules and so on. So it's very important for me also to have this translation from our research into practice and policy and standards. And I have been asked today to deal with human dignity and the link with human rights in prisons. Of course, there are many challenges that we could deal with, but I will focus today on two fundamental challenges. One is the role of degradation as a component of punishment in itself. And second, the power relations and extreme dependency of incarcerated persons in prisons that are still to be considered total institutions. So when we talk about degradation, what does it really mean? It has been defined as treatment that makes people feel inferior, lessened, lowered. And already in the 50s, it was claimed by empirical researchers that symbolic degradation already starts at a criminal trial, because when a citizen becomes officially an offender, is found guilty, it results in some kind of status degradation, considered as a somehow lesser person in the social stratification of how we deal with fellow persons in our society. And of course, since the 1950s, again, we also know that prisons also have some degradation mechanisms. And we see that although some of them have disappeared in our modern prisons, some still remain. And in some recent empirical research we did in Belgium, most prisoners, for example, still refer to the fact that at entry into the prison, they are strip searched, they have to take on uniforms. And that's something that, of course, happens in many other countries as well. A second important mechanism is that, as Thomas Ugelvik described for Norway, and Norway is known for, its more humane exceptionalism, prisons still create prisoners. And what does that mean? It means that on the one hand, the identity of prisoner becomes paramount. It's more important than whatever you have been before. A husband, a good worker, a sportsman. Prisons create prisoners in the sense that they are bodies that cannot be trusted. We think about incarcerated persons are not allowed in all parts of the prison, for example. They are limited to certain areas. And morally, they're very often considered as morally inferior or bad or mad or ill, or anyway, against something below how we would consider other people. And in many countries, we see some of those also in the occupational culture of prison officers. And of course, I have to say immediately that many countries have shown that there are variations within this occupational culture, between prisons, within prisons, between teams, between individuals. But on the other hand, on the whole, we also see that prisons as institutions create some kind of sameness principle in the way how incarcerated people are treated. And the sameness principle results from the prison routine, from the institutional interest that take over, and the individuality of incarcerated persons tend to become less important than those institutional interests. This has been called bureaucratic indifference or institutional thoughtlessness. There are many different names for it, but it's the same idea behind this principle. In many countries also, we see that occupational culture of prison officers has a quite strong oppositional culture against incarcerated persons. So it's a very us versus them culture. And that is also sometimes seen through the language that is used. Sometimes really calling incarcerated persons by not so very nice names, or sometimes unwillingly, again, because of the institutional interest. Like a study showed that in the UK, they use feeding time to say when incarcerated person can have their meal, which doesn't sound really, more like a zoo than an institution where people are held. The power relations in those prisons can still be considered within the context of the total institution. Of course, we know it's something that was defined in the 1960s, and there has been quite some debate within the penological literature whether our modern prisons can still be considered as total institutions. But when you look at the core characteristics that Goffman gave for a total institution, those have not changed. It's still batch living. People are put in an institution with people they have not selected. They are forced to live together. The institution tries to control the time and the different life fields of their inhabitants. And there is a strong bureaucratic organization to take care of the needs and interests of the inhabitants. So when we look at, as I said, some of those most recent empirical research, we still find in our modern prisons that the experience of the inhabitants is still the shock of entry, feelings of physical humiliation, feelings of fear, uncertainty related both to the personal situation of the incarcerated person and the institutional context, especially, of course, for persons who are incarcerated for the first time. But what was very strong, and not only in the prison, because this research was also done in a rehabilitation hospital, and the similarity between the prison and the hospital was very striking, is the feeling of extreme dependency that the inhabitants have on frontline staff. And dependency has been defined as a situation in which you need something or someone and are unable to continue normally without them. And this situation is seen as normal for children, but not for adults. And again, it's something that you will hear over and over again, incarcerated persons saying, we treat it as if we were children. We're back in kindergarten. So even in our modern prisons, inhabitants lose control over most aspects of their daily life. And the power of prison officers has recently been described as a very intimate power, in the sense that it comes very, very close to the most intimate parts of a person: autonomy, privacy, identity, family roles, and so on. So that's important to remember. And of course, we know, and the fact that CPT started in 1989 testifies it, that we know that unchecked power enhances the risk of abuses of that power. So the human dignity and human rights in prisons are very important, first to counter those mechanisms of degradation by recognizing the continued humanity of incarcerated persons, irrespective of their criminal acts, to rebalance those unequal power relations and counter the risk of unchecked use or abuse of power. But interestingly, and that's the positive part of it, and if I have time, I would like to end with that, it also fosters the legitimacy of prison staff, and hence indirectly also compliance within prisons. So human dignity is a very complicated concept, because it has been defined in many different ways. There are religious definitions, a personal definition where it's a very subjective feeling. Only the individual person knows what his or her dignity feels like. And then you have the social dignity, which is very important here when we talk about prisons, which is defined by society, by legislation, or by courts, deciding what type of dignity should be protected. And in Europe, when we talk about prisons, we see that this concept of dignity has more and more been translated into human rights, precisely because it was thought that that would then maybe be more easy to try to implement, rather than this vague concept of dignity. And we have already heard how the Council of Europe deals with that, European Court, CPT, the recommendations. Just to say that this is much more than soft law. It has already been emphasized also earlier here. But of course, the case law of the court in principle is binding. The work of CPT is binding because it's based on a convention, and many of the recommendations now have been used by the court, and have the court, by doing that, has turned it into much stronger than just soft law. Human rights of prisoners for the last 20 years have been recognized by the European Court of Human Rights, stating that prisoners in general continue to enjoy all the fundamental rights and freedoms guaranteed by the convention, save, of course, for the right to liberty. And especially important there is Article 3 of the convention, states that there is an absolute prohibition on torture, inhuman and degrading treatment. I don't have time to go into the other rights. I think that's a separate seminar. But even though the concept of dignity is never mentioned in the convention itself, the court has affirmed over and over that dignity is a core concept for the interpretation of the convention. So we have to take again into account both the concept of dignity and the more formal human rights of incarcerated persons. So as I said, I was asked to deal mainly with Article 3, but I think it's important to say a few words about the right to life, which is in Article 2, because of course that's also something that can be threatened within prisons, as prison staff is entitled to use force, sometimes lethal force, in those institutions. What is important to know is that the court has reversed the burden of proof. So if an inmate dies within a prison, it's now up to the authorities to explain why lethal force was used and whether it was necessary, legal, and proportionate. And the court will also look into the training that the staff has received, how the planning and the control was exercised over the intervention. And the person, the victim, does not even necessarily have to be killed. It's sufficient that the person's life was at serious risk. Interprisoner violence is also something many countries know in their prisons. People can be victim by fellow prisoners. Again, authorities can be seen as responsible if they fail to provide sufficient information or sufficient prevention measure, especially in the case of mental health issues. And of course, healthcare can also, insufficient healthcare can also lead to threats to the right to life, like not enough medical care, mental health care, or suicide prevention, which also must include psychiatric care. Now, the prohibition, I already said, of torture or inhuman and degrading treatment is absolute. This means that under no circumstances there can be a derogation. So even if it concerns a suspect or convicted of terrorism, or in case of conflict, armed conflict in the country, so it's absolute, and it's linked by the court again to this respect for human dignity. Since 1970s, the court has defined those three concepts: torture, inhuman, and degrading treatment. And we know, I can't go into this, that the CPT reports again have been very influential over the last 20 years to influence the case law of the court. Now, torture, I don't think I have to explain, is of course prohibited in all its forms. Again, I don't have time to go into details, but I suppose the PowerPoint will be available afterwards. So those who are interested can find some of those examples of judgments by the European Court: Palestinian hanging, sleep deprivation, rape, force feeding of a person on hunger strike, but accompanied with great physical pain, was considered torture. The threat of torture has been considered to be torture in itself, and severe beatings that had absolutely no legitimacy. Inhuman treatment is the second most serious, if you could say. Again, use of physical force, the court has decided there should be a reversal of the burden of proof. So again, it's for the authorities to put forward evidence that the use of physical force was indispensable and not excessive in the given case. So judgments that we find where this was not the case would be disproportionate use of force. For example, a person is rightfully forced by prison staff, for example, to go to solitary confinement, but once the person has been put under control, staff continues to beating or to use physical force, which is no longer necessary. So then this would result in a violation of Article 3. The same for use of means of restraint, the court accepts that it can be necessary and it can be legitimate, but if it's still used beyond the time that it was necessary and legitimate, it becomes a violation of human dignity and of Article 3. Again, other, for examples, threats of torture, force feeding without any medical necessity. Of course, the court will also look here into professional standards, medical standards, how to deal with incarcerated persons on hunger strike. In certain European countries, life-sentenced persons are under very special, very restrictive regimes, often in very poor conditions. This has been found to be inhuman treatment. And there was also some special judgments in relation to the extraordinary rendition to CIA secret detention sites in Europe, where torture practices happened on the continent of Europe, not by European staff, but by American staff, but condoned and facilitated by the European countries who allowed that kind of secret detention sites. So here, those European authorities were found also to violate Article 3. Degrading treatment or punishment, it's the lesser of the three, but of course still very important. Lack of respect or diminishing human dignity, causing feelings of fear. What is important for the last 20 years is that the court changed its case law and now has decided that this degrading treatment or punishment is not necessarily willfully imposed. In earlier times, this was not the case. The court would expect it to be willfully imposed by staff. That's no longer the case. So degrading treatment can result from a lack of resources, from a lack of prison staff, a lack of medical care, and so on, even if it's not purposely done by the staff. What is important also is that the courts always stresses that to have a degrading treatment violating Article 3, it must go beyond the inherent suffering and the inherent humiliation of imprisonment. So the court accepts, in fact, humiliation as part of imprisonment, but it must go beyond what is seen as normal level of suffering and humiliation within imprisonment. And the court only deals with individual cases. So contrary to the European prison rules or the CPT standards, the court does not say what a good regime is. It does not say what a good behavior by prison staff is. It says negatively what a violation of Article 3 is. So you always have to look in the individual cases to understand more precisely what is meant. And that's why the combination of those three instruments, the court, CPT, and the recommendations, is so important to understand what good standards are for imprisonment. So this relates to conditions of detention, overcrowding, lack of sanitation, lack of individual beds, the treatment of disabled persons in prisons, lack of physical or mental health care, prison regimes like solitary confinement. There's a whole session about this in a parallel session. So this is, of course, very important. High security regimes, for example, imposed on people with mental health issues, has been regarded as a violation of human dignity. Prison regimes offering no activities, no education, no sports, no libraries, and so on. So very impoverished regime in itself is already sufficient to be a violation. And suicide prevention, for example, leading to disciplinary isolation is also a violation of Article 3. Specific behavior by prison staff is also considered, for example, staff having persons coming in the prison forcefully shaving bald, strip searches without any security reason has been found by the court to violate Article 3, and the removal of drugs or other evidence from person's body without medical support has also been found to be a violation. And of course, since 2011, the court has decided that where such violations result from systemic failures, they have the new instrument of pilot judgments, where the country then is asked to produce reforms to take on those systemic failures. So you see, it's already quite a lot that is in the formal human rights protection. But what we see from empirical research in prisons is that the feelings of personal dignity and personal humiliation go beyond these human rights. So if we really want to strengthen human dignity in prison, we of course have to look at the human rights, but we have to look beyond the human rights. So even the human rights are not sufficient if we want to tackle all the mechanisms of degradation and humiliations. And I started by saying that dignity is a very difficult concept, but at the same time, again, research shows that prisoners are very articulate about it, and they know very well when they feel humiliated or when they feel they have been treated decently or with retaining an identity. So we really have to look into this inherent humiliation as well. For example, strip searches. The court and CPT and the European prison rules accept that strip searches are sometimes necessary. And if they're not with additional humiliation, they will not be found to violate Article 3. But for most prisoners, it is an inherent humiliation to be subjected to strip searches. So prison staff should take into account these feelings of inherent humiliation, even if it is protected by European human rights. What we have called institutional violence is independent from prison staff behavior. The passive security, the cameras, the walls, the deprivation of liberty in itself, that is often felt to be a violation of the dignity and the identity. The sameness principle I referred to at the start, that is often felt to be contrary to the individual dignity and individual identity. People who have never been involved in drugs will be seen as a drug risk. People who are not thinking about escaping will be considered an escape risk. So the sameness principle follows this prison create prisoners. So prisoners are subjected to the same kind of practices because they are seen as having some core characteristics that puts the institution at risk. And there's quite some recent research also about the emotional masks that incarcerated persons have to build up in order to survive in prisons, which then are often felt to be contrary to their personal identity. And of course, again, we know that prison populations show a very high prevalence of trauma, and not only female incarcerated persons, but also male incarcerated persons. And a lot of mental health issues have been shown to be present in prison populations throughout Europe. So what is the solution? On the one hand, we have this group of incarcerated persons with their demands for dignity, humanity, protection of identity, a history very often of trauma, post-traumatic stress disorders, the pains of imprisonment, and then prison officers where the occupational culture may be more tending towards the sameness principle and the institutional interest. And I think the solution is to emphasize the professionalism of prison staff, to emphasize on the legitimacy of how their authority or power is exercised. And again, this is nothing new. Sparks, Bottoms, and Hayes started in 1996 with emphasizing the importance of legitimacy. But I think we know more now about how to achieve legitimacy in such a challenging context. And I very much like Bottoms and Tankibi a text of 2012 on the dialogical approach to legitimacy, which is both the people who exercise the power and those who are subjected to the power need to recognize this legitimacy. So it's in the interaction that legitimacy is construed. And when you look at how they define the formal legality of the power, then I think human rights are essential because they are part of what we would call constitutionalism or rule of law. But when you look at the self-legitimacy that is necessary in this exchange in power, then I think dignity is really important. And then we have the whole concept of procedural justice that can help us to attain this dignity, this feeling of respect for dignity. And again, both for those who exercise the power and those, in our case, incarcerated persons who are subjected to that power. So a lot has been written already about procedural justice. I don't have time to go into it. Just say maybe there are two important aspects. One is the quality of the decision making. How are prison staff deciding? How is their decision explained? How is it motivated? even if they refuse a request of an incarcerated person, if they explain why it cannot be granted, most persons will accept that this is the case. There's a lot of empirical research that testifies to this. The quality of treatment is more personal, more about how you feel treated as a human being, in your own personal dignity, in your privacy, and so on. I think everyone who has already been in touch, most of us maybe have already been in touch with police officers. I think we know what we're dealing with when we say how we want to be treated with respect and as a human being. So, as Sparks, Bottoms and Hayes said already in 1996, every instance of brutality in prison, every casual racist joke and demeaning remark, every ignored petition, every unwarranted bureaucratic delay, every inedible meal, every arbitrary decision to segregate or transfer without giving clear and well-founded reasons, every petty miscarriage of justice, every futile and inactive period of time is delegitimizing. So, of course, this is very complex for prison staff because what they have to do is incredibly complex. As Shatmaruna wrote very recently, at the minimum, officers are expected to have a level of expertise about suicide, self-harm, violence, bullying, drug use, addiction, race relations, mental health, nutrition, medication, exercise, and something called rehabilitation. So, of course, training and education is essential for prison staff to support them in this very complex exercise of their functions. But in many countries, training and education is too minimal to really answer to these very complex challenges. And I would like to finish with the conclusion that, of course, training of prison staff is essential to achieve this. And we already heard some of the tools that have been developed more recently on human rights. Andrew Coyle, most of you may know him, a former English prison director, wrote a handbook for prison staff on a human rights approach to prison management already in 2018. Of course, all the recommendations of the Council of Europe can be used. As far as human dignity is concerned, I think prison research and prison researchers can be helpful in explaining more those lived experiences of prisoners on this level of the more personal human dignity. Sorry. There are also some interesting recent publications like The Good Prison Officer, a book written, published very recently, 2023, by former incarcerated persons who have desisted from crime and have themselves become professionals within the criminal justice system and are sometimes now training prison officers. And it's very interesting to read their experiences of how they felt they were treated correctly when they were incarcerated. And of course, the European prison rules also recommend to have prisoner committees or to have instruments through which incarcerated persons can communicate with staff and with prison management on issues that are of a more global interest to them. And then, of course, again, nothing new there. Dynamic security, interpersonal relationships are important both for the protection of human rights and dignity and for the legitimacy of prison officers. And again, we have the CPT standards, we have European prison rules, we have a lot of prison research. And we also see there are some interesting techniques to use in this prison officers training, like experimental learning, where prison officers have to play the role of the detainee, or where they are forced into certain positions that incarcerated persons have to go through so that they realize what it means to be in that kind of position. So if people are interested in some of the researches, you can find it here. So I hope I kept my time more or less. And of course, I'm open to questions.
Thank you very much, Sonja. I think we can use this time and space for displaying any questions. You can also raise your hand, and then based on how many questions there are, you can unmute yourself and ask a question yourself. And we try to create a discussion here. So we have enough time. 15 more minutes until we go back to the main room. So please, the floor is yours.
May I ask a question?
Laura raised her hand. maybe first Daniel. Okay, or I don't know.
No, go ahead, Daniel.
No, go ahead, Laura.
Sonja, thank you so much for this fantastic input. You said something more specifically about trauma-informed approach, and I have been talking to people, and in fact, there is this perception that trauma-informed approaches are very like set up for women. You said exactly this key sentence of you. There is also this reality of men having trauma, and so there is a need of a trauma-informed practice also for men. Is there some research around, or what made you say this?
Yes, if you will look at the very first reference in my bibliography on my slide, it's a research done by Alison Liebling and colleagues in the UK, where trauma-informed training was decided for prison staff in UK prisons. And it started indeed in female prisons, but then it was also extended to male prisons. And the idea was that prison officers would receive training in trauma recognition, not, of course, in order to offer treatment, because that requires specialist expertise, but to realize what trauma means and to take it up in the knowledge they have of the consequences of trauma in how they deal with incarcerated persons in their daily interactions. However, the research that they performed showed that they compared two prisons, one where this official trauma-informed practice was introduced as part of the official policy of the prison, and another where this was not the case. And in fact, the experience of both the incarcerated persons and prison staff were still quite similar in both prisons. Prison staff who had received the training thought it had been very helpful. It had helped them in dealing with the people under their authority, while the incarcerated persons felt it hadn't changed anything, and they still felt that their traumas were not taken into account by prison staff, by prison officers. They would still receive ideas like, well, you know, time to go beyond it, grow up. So not really recognition of all the emotional consequences that trauma has had in their lives and still may have in how they experience imprisonment, because what the research shows is that imprisonment very often repeats some of the traumas that those persons have suffered during their childhood or their adolescence. So the article concludes that the researchers are absolutely behind this idea that you need this kind of training, but we're not there yet. And I think, of course, the dilemma is that you can't train the prison officers to become treaters of trauma. So how much knowledge do they need to fully understand what the experience is for the incarcerated persons? And that's what many of the interviewees said, you know, well, okay, even some maybe are more kind to us, but that doesn't help us because nobody is helping us with our trauma. So you need both. If you only train prison officers and there's not the professional support for treating really the trauma, then of course it will not help either. So it's an and policy, I think, that you need. You need the professional expertise and you need the awareness raising for prison officers.
Thank you.
But again, there's quite some research also by Manuela Dudek on long-term prisoners, where you see that trauma is also very much present in male populations in European prisons.
Thank
It's
you.
also
Thank
in the
you.
list.
Daniel is next.
Yes, thank you. Thank you, Sonja, for this presentation. And actually, it's more like a reflection, and I would like to have your thought on it. Since you were mentioning those recommendations, and PCCP is doing a wonderful job kind of developing those standards and principles, giving kind of guidance to those prison and prison organization. But it seems like to me there's a shift, because now more and more you got the European Court using those recommendations, soft law actually, to make them a kind of come strong, and it's a good thing, to those national authorities are saying, okay, you're not complying. So should we keep saying soft law, or is it still relevant?
Very interesting. I was chair of the PCCP for 6 years, and on the one hand, when we were trying to find a compromise, we would always say this is just a recommendation,
Exactly.
So this is what we should aim for. But then as the court was more and more using them as what the court said were the legal instruments for its case law, we got more and more resistance against those recommendations, because, and sometimes, from governments, we would not maybe expect it, saying, no, these are not soft law anymore, because then we get the court on us. So we saw there was a kind of more restrictive attitude by national authorities to accept standards in the so-called soft law. So it has become harder in a way to get those standards accepted because of this. On the other hand, I think it is a good thing that we have this interaction, because I think they're very complementary. CPT, in fact, has become the fact-finding instrument for the court. I mean, it's CPT who's bringing in the evidence of what's happening in practice, and the court has used CPT reports over and over now. So it helps the individual complainant if CPT has visited that institution. And the recommendations, again, because they show a consensus over all the different regions in Europe, also strengthen, I think, the standards, because that is what happens beforehand. You're facing with 46 countries now, coming from very different traditions. And when you reach a consensus, all those different oppositions have partly already been discussed and have been overcome. So when I had to defend the recommendations, it very much helped that we had all those discussions beforehand.
Thank you.
But of course, there is still a lot of soft law that is not used by the court as well.
Thank you very much. Should we move on to Sergio? I'm not sure which one of you, first, Sheena or Sergio.
I think Sergio, I'm not sure.
Okay, go ahead. We have 5 more minutes for questions before we have Sonja's closure.
You can go. Then I go.
Go ahead. Oh.
Me? Yeah. Okay, no, thank you very much for your presentation. That was really interesting, and I've got so many questions. I work in the Scottish Prison Service, and I'm just astounded by, going back to the earlier presentation about how short the initial training is for some prison officers. In Scotland, it's just a matter of weeks. So there's questions there of how much basic issues of dignity and human rights can be brought into a training when so much of the focus is on security. But we've been moving more to a sort of value-based training, and in Scotland we've got a different prison system from England and Wales, where Alison Liebling was writing about, but still, you know, a lot of her writing, because it's about culture and rights and everything, is still as relevant. I wonder whether it's more about leadership. We're talking about training prison officers. What we've found in Scotland, and we've just had a new corporate plan for the next few years, and we've introduced a trauma-informed approach across the prison service in Scotland, where we're starting at leadership level and training leaders in what it means to be trauma-informed. And I was interested, I think one of the last slides that was shown, I think it's, sorry, let me just get it up. It talked about dynamic security, and I think in Scotland we would we would almost put that round, that yes, security is important, but and that's where you want to get to, but respecting the individual. And so if you respect the individual and have that active listening and all those things that Alison Liebling talks about, then that will lead to security. And when you put the emphasis on security, it almost predefines your mindset, if you like. So it's turning the whole thought process upside down. But at the end of the day, I always have the question, is the underlying issue, can the degrading aspects of imprisonment be overcome by training, by cultural change, by this application of human rights at whatever level?
Yes, I have put my email address on the last slide, so please feel free. We can continue the discussion maybe afterwards and exchange more information. I absolutely agree about the value-based training. And of course,
sorry, excuse me, Sonja. Maybe we can let the two others also ask questions. We take them all in, and then you can respond. Maybe is that?
Okay. If we
that be an idea?
Because we have. Yes, I don't have time for everything, but okay.
No.
Yes, please. Yes.
Maybe Sergio shortly.
Okay. Yeah. Then thank you for the presentation. I want to ask if you know some training that is proving that evidence-based proven that is effective to change the prison culture, because I read some research that the training finally will be like invalidated by the prisoner culture. It happened a lot of time. I read some ethnography in Brazil specifically, and then I want to know if there are some training effectively change the prisoner culture, or maybe we have to work more on the staff selection also, and not only in the training, but how we select and why the people start to go to work in the prison. As for example, the APAC system, the prison without police that I studied in Brazil do, that they selected the people for working that have voluntary experience in prison, that are former prisoners and so on. Then, yeah, thank you.
And we have one more question from Chetwind. Please go ahead.
Hello, good afternoon. I work for the CPT. So thank you, Sonja, for excellently overview of the whole issues around dignity. I think the question that I always come when we see this is that it doesn't matter how much training are given if the fundamentals in a prison system are not functioning. And by that, I mean, if you have a prison system that is overcrowded and you're then putting in persons, doesn't matter if you train them well, they are immediately overwhelmed. And I think a really interesting example of how to and this is going to be a bit harsh, how to destroy a prison system is to look at England and Wales from 2012 with the austerity, where you take off 30% of the top management or prison officers on the ground, and you lose control of the prison. And it doesn't matter now how many times you put in new prison staff, you train them, put them in, they're overwhelmed. And therefore you've lost the ability to actually provide any kind of a system that it can help the prisoners progress through and then prepare for reintegration. And that issue of overcrowding, and the reason I wanted to raise it is that if governments don't actually go back to the real basics of what they're trying to achieve through prison, and it becomes more warehousing, then all the various standards and training that are put forward are undermined from the very beginning. And that is something that, when we put forward, a couple of years ago, we put forward a little section about decency threshold. What are the minimum that we should see in prisons that prisoners are provided? Because even the minimum is not being taken. And I think it's also very interesting the way you brought that back also to the case law. And we spoke earlier about the European, the soft law, so-called. I think one of the things I've noticed in the last 20 years is how we see the court, or many governments are actually waiting for court judgments before they will take a lot of action to start doing fundamental reforms to bring down the prison population, or to make sure that certain practices within their prison system are changed, whether it be forced feeding, whether it be solitary confinement, or that. So I think it's really nicely the way you brought the thing together, and I think that's essential. But I think that underlying it all, there is a real need for overcrowding within prison systems to come down, to allow space to then enable officers to be, firstly, sufficient, because in most countries there aren't sufficient, and then secondly, as you're saying, to be properly trained through the system. So there are just a few reflections on an excellent presentation. Thank you.
Thank you. Yes, I agree with all that has been said. My course on prisons used to be 30 hours. So of course, to go back to Sheena, I think dynamic security, I completely agree that respect is the first and foremost, and also in human dignity. It's the concept that's always coming back, also in interviews with incarcerated persons, respect. However, how is it translated? And I think the fact that we use dynamic security, because in many countries, security is still foremost in the occupational culture of prison staff. And as you said, they're mainly evaluated on that topic as well. So it is about leadership. It's also the whole evaluation system that is applied to the prison officers. Because if they have an escape, then they will be held responsible, sometimes even under criminal law. So, having this dynamic security on the one hand, I think tries to go along with their concerns for security, but stating, that you really need this interpersonal form of security. And sometimes it starts by being used purely instrumentally, not really because they want to respect incarcerated persons, because they see it works. And then when they see it works, then maybe they can also see it helps if you have respect on both sides. So I think it could work both ways, probably depending on how the training is and how the occupational culture is. In some particular prisons, it may be more easy to start immediately with respect because they have already accepted that idea. Of course, selection, Sergio, is equally important. And I think one of the problems we see with the training is that in many countries, the training is done by prison officers. So, for example, in Belgium, we have a legislation that is full of human dignity for incarcerated persons. But if the training is performed by prison officers, they translate already this legislation into what they know about their practice. And then in research, we hear from newly appointed prison officers that what they really remembered is that there is one article in that legislation that tells that prisoners have to obey prison officers, and that's what they have remembered most. You know, so I think you need also, of course, the selection, but also I think the lived experiences in the training by people who have been subjected to imprisonment. And I think, again, I just discovered this book of 2023 3 days ago. So The Good Prison Officer, written by former incarcerated persons, I think would be really interesting to see, because they may have gained some legitimacy because they have desisted from crime and because they have become professionals themselves to go into this dialogue with prison officers. But of course, you also have to take into account local cultural differences. And as you say, in some countries have former army and military people who become prison officers. So you will have another form of occupational culture there as well. And then, of course, yes, again, of course, I agree that training is not sufficient. And, you know, I started my academic career by working on prison overcrowding in 88, and it's still there, and it's still there in all over the world and all over Europe. And the reason I didn't end with that, because that's such a systemic feature that is linked to penal policy, criminal policy, populist politicians now, and it goes so far into what I could not get into those 20 minutes that I thought, well, let me stop with something like training.
Thank you very much, Sonja. We are now, I'm getting signals that I need to close all the rooms, but thank you very much. It was really a pleasure, and thank you for your contribution. Just wanted to ask you, can I also share maybe your email address with the participants here? Is it okay for you?
Yes, sure.
In case you have any further questions directly, then you can contact Sonja. I just send it in the chat. So now I will close the room, and you don't have to do anything. I'll see you in the main room. It takes 1 minute. Sorry about that. But you can also leave.
Perspective of what directly affected, sorry.
Yeah. Okay, good. So we will get back to that. Let me see. So I think all 3 groups now are back in the plenary.
Sorry, just a few more seconds, I think. It takes always a minute until it stops all the rooms. So.
So this was the first time we used the breakout function, which you may have noticed, but it was also a little tryout for us, but I think it worked pretty fine. First reflection is that there is need for even more time, probably, for a breakout like this. So that's a learning for next time. Just to sum up, I would like to ask the speakers of each session to briefly summarize what was discussed in your breakout session. And Jean-Sébastien, if you want to begin, I would be very...
Sure, yes. So good afternoon, everyone. So I was facilitating the breakout room on LGBTIQ+ detainees. We had a small group, but a rather interesting discussion with participants from a diversity of backgrounds. So it would be very difficult to sum it up only in a few minutes. So I'm not going to do justice to the discussion we've just had. But what we did first was pointing to the scarcity of standards with regards to this category of detainees in detention. And but we also mentioned the emerging international case law, in particular from the European Court of Human Rights, which is emerging, as I say, but there are some interesting rulings. We've also outlined some of the key challenges in relation to the handling and care of LGBTIQ+ detainees. And we actually, in the discussion, and that was no big surprise, we had a bigger focus on trans detainees. And in that regard, we discussed how politicized the question of transgender detainees has become, with the example of Scotland. And there was a case of a trans women that received a transphobic treatment in the media, and there were repercussions also in other countries. So I think it doesn't help develop sound policies in that regard. And I would say that if there were only one takeaway messages, it would be that when we draft any policy document or piece of legislation, it would be to really try and apply what we call the nothing about us, without us principle, which means that the people who are most directly concerned should be directly involved in that drafting. So that means reaching out to LGBTIQ+ association and experts. And last but not least, we also heard during that session that Penal Reform International is developing a briefing document on national policies regarding LGBTIQ+ detainees across the world. So that will be a very valuable guidance, and I think it will be out at the end of this year or early next year.
Thanks very much, Sean. Should we continue with Dirk van Zyl Smit and your session on solitary confinement?
Yes, our session too was a relatively small group, and we focused initially on the problems of having slightly different definitions of what solitary confinement is in different systems, and also the question of limits, maximum periods that could be imposed. From the participants who spoke about their own countries, it became clear that there are many countries that do follow standards, at least formally do follow standards, both those of the European prison rules and of the Mandela rules, which set Mandela rules setting a clear time limit, and the European prison rules setting an indirect time limit, but trying to limit solitary in the narrow sense to disciplinary cases. What also became clear to me was that one area in which there is a problem is where courts intervene and impose or order solitary confinement for a set period. People who run prisons are bound by that. And if a court orders a longer period than what the European prison rules or the Mandela rules would allow, it's difficult to deal with. And I pointed out that at some stage that would be challenged before the European Court of Human Rights. And it is a very interesting example of how European jurisprudence from the court will eventually interact with the court, but with the soft law. But in some ways, we're still at early stages in this area. But I also thought it was an interesting discussion. So thank you also to my colleagues who participated.
Thank you very much, Dirk. And last but not least, Sonja Snacken, what was highlighted in your session?
Yes, as we were dealing with, in fact, the relation between human dignity and European human rights as they have been formally recognized, but I think dignity goes beyond what European human rights recognize, especially in the experiences of incarcerated persons regarding humiliating practices that may be condoned by European human rights. As I ended my presentation with some emphasis on prison staff training, there were a few questions about how far training can really change occupational culture, whether dynamic security is really a good concept to try to influence prison staff culture, because it again emphasizes security. The example was given of the Scottish Prison Service, where they had tried to have a more value-based training, emphasizing respect, where they then expect that dynamic security will follow. if respect has been taken up as a really important value in the way prison officers deal with incarcerated persons. And the emphasis on leadership, where I think not only leadership, but also the formal evaluation of prison officers says a lot about how important respect or dignity is considered when prison officers are evaluated in their professionalism. Of course, the selection of prison officers was mentioned as equally important. And of course, many countries have very different profiles of people coming into the prison service. So that may raise additional challenges like military persons or police officers. And then, of course, the fact that prison officers training cannot solve the more systemic failures like prison overcrowding that we see in many European countries. And of course, we know that European Court has changed its case law, and there are a lot of pilot judgments now in different countries on prison overcrowding. What was interesting, I think, was that Chatwin van CPT said that now sometimes European governments are waiting for a judgment by the European Court of Human Rights before they start acting at the policy level. So I would be interested to go further to see why is it? Is it because it adds some legitimacy that they can say to the public, well, you see, now we have to do it, as we know it happened, for example, in Italy after the pilot judgment. Well, we don't really want to do it, but Europe forces us. So maybe also in these populist times, it adds an argument for governments that they have to do something about those kinds of systemic failures. So, well, of course, too much to discuss in the time we had. So I think I would agree that it would have been good to have more time afterwards.
Thank you so much, Sonja. There was a great summary of many urgent topics in the field of human rights in prisons. And I see